The Supreme Court on Wednesday held that a Deputy Speaker of Parliament or any person presiding in the absence of the Speaker is entitled to be counted for the purpose of forming a quorum for decision-making. A 7-member panel of the Apex Court presided over by Justice Jones Doche also held that a Deputy Speaker of Parliament for any person presiding in the absence of the Speaker is entitled to cast a vote on parliamentary proceedings. However, many have criticized this decision, describing it as an unfortunate interpretation for convenience that sets a dangerous precedent of judicial interference in parliamentary procedure for the future. We gleaned the thoughts of a private legal practitioner, Mr. Benjamin Antiedu, on this subject. Hello, good afternoon, Mr. Antiedu, and thank you so much for joining us on News Hour.
Good afternoon. You're most welcome.
Thank you very much. The minority calls the judgment as a travesty of justice, while the majority describe this judgment as refreshing. How do you see it?
Thank you very much. Yes, this is the usual reaction to a court judgment. Definitely, there's no draw when it comes to litigation. So one side will win and one will lose. And definitely, there will be a response from both sides. So, but personally, I have a concern with the judgment. The first is that, there are two police numbers that are required by the Constitution when Parliament sits and takes decisions. The first one is the quorum number of 1/3 that is required to be in the chamber before Parliament can sit. For that one, the Constitution is clear that when a Deputy Speaker is presiding, he does not count towards securing the quorum number for Parliament to sit. Then the second quorum number that is found in Article 102 is the quorum number of hello.
I can hear you clearly. Please can you go
so the quorum number under Article 104 is the one that is required for Parliament to take decision. So you see that we have two quorum numbers to be obtained, one for Parliament to sit and one for Parliament to take decision. So the concern here is that the Supreme Court's construction is to the effect that even though a Deputy Speaker cannot count towards quorum for Parliament to start sitting, he can be counted as part of the quorum number for decision making and even vote. So it creates some kind of internal inconsistency between the relevant provisions of the Constitution. Here we're talking about Article 102 and 104. So that is where the first concern is. Then the second one is that, the Supreme Court coming to this conclusion has even declared unconstitutional Order 109(3) of the Standing Orders of Parliament. Parliament, pursuant to Article 110, has enacted standing orders to regulate its procedures and to enable it to discharge its constitutional duties. And so, making this, there is superior freedom of Parliament in making procedures to regulate its proceedings. And Parliament has made regulation respecting the right of a Deputy Speaker who is presiding over the proceedings of Parliament, that when you are presiding over the proceedings of Parliament as a Deputy Speaker, you lose your votes. That is what Parliament has decided. And the Constitution is silent on that. So to say that that provision sits in contravention with the constitutional provision is somehow difficult to accept. But that's my personal view. A decision of the court, and particularly the Supreme Court, is final and effective and binding on all persons, except maybe when it's overturned on a review. So I may not agree that it's an interference with, with the parliamentary powers of adopting some procedure or directing Parliament as to what to do, but it's a regulation that is found under the Constitution, just as Parliament has its own strengths and powers under the Constitution.
So you just quoted Article 110 of the 1992 Constitution. So per this judgment, would you say that the independence of the legislature has been undermined?
Yes, that is the point I'm trying to make, that definitely the free hand given to Parliament to make its own rules or set its own procedure has been undermined. Because the Supreme Court in J.H. Mensah and the Attorney General emphasized that whatever happens in Parliament is a closed book, to the extent that once what Parliament agrees to do does not infringe on any constitutional provision, then there's total freedom for Parliament to do that, which I think in this case is one of them.
Do you see the work of Parliament suffering in any way per this ruling?
That I don't envisage that at all. Just a clarity on this one. I think that even in the middle of the confusion or appearing confusion, this rather settles the matter and brings clarity so that the House will know what to do at any point in time. But that's not to say that I agree with the decision. But the Supreme Court acted within its powers under the Constitution, and once they have given the judgment, it's final and binding on all of us to work with it until we secure a reversal through a review.
Okay, so before you go, can this ruling be challenged? If yes, what is the process?
Yes, they can be challenged. They can be challenged, especially by the plaintiff. He can go back for a review. That is what, if he believes that is, there's a chance to do so. But what we must know is that the right to appeal before the Supreme Court, the right to review before the Supreme Court, I must say, is not automatic. You have to demonstrate that there was gross miscarriage of justice. In simple words, you are demonstrating to the court that it failed to apply a binding maybe decision or rule of law in arriving at the judgment. And if it had adverted its mind to a different, that the law which it ignored, the decision would have been different. And when you have a unanimous decision such as this one, then that would be a very tall order.
All right, thank you very much, sir.